Hello, I'm Barbara Zeitler, a property law barrister practising from Land Chambers.
And I'm Harriet, a commercial and property law barrister also practising at Land Chambers.
In this short podcast, we would like to explore two recent cases that show what can happen when relations between neighbours sour. We want to talk about unneighbourliness in a property law context.
Yes, I will first be looking at the case of Misha Manson-Smith and Alexandra Manson-Smith and Mark Arthur Worry. In this case, Deputy High Court Judge Matthew Gulick QC considered what relief should be given to claimants following a summary judgment having been entered in their favour for a claim for injunctive relief and damages arising from nuisance, harassment and breach of covenant in the claimant's lease. In relation to the parties, the defendant was the registered proprietor of the freehold of a property in Hackney, which had been converted into 3 flats, A, B and C. The lease of Flat A was first granted in 1991 and was purchased by the claimants in 2014. Since the beginning of the lease, the claimants had been subject to a significant course of harassment by the defendants. This was because the defendant had a long-held belief that the plan annexed to the lease of Flat A held by the Land Registry was forged. Specifically, the plan indicated that the front paved garden area formed part of the demise of Flat A, and that leaseholders of Flat A had the right to use the whole of the rear garden area beyond the small private courtyard. However, the defendants did not believe that the lease conveyed those parts of the property, and the lease held at the Land Registry was therefore forged. But in any event, it wasn't necessary for the learned Deputy High Court Judge to determine whether the allegations that the lease was forged was correct or not, as this matter had already been conclusively determined against the defendants due to reasons that I will explain shortly. In terms of procedure, the claim was issued in 2019, in which the claimant sought injunctive relief and damages arising from the defendant's nuisance, harassment and breach of covenants in the claimant's lease, and the claimants relied on Protection from Harassment Act 1997. The claimants claimed a number of acts of harassment and nuisance against the defendant, ranging from 2014 to 2019, including parking then abandoning vehicles in the rear garden of a property, which resulted in a security risk to Flat A, which was ultimately burgled, as well as dumping large volumes of rubbish in a front paved area, including a mattress and smashed wine bottles, causing large volumes of rubbish to be thrown from the windows of Flat B and C into the front paved areas belonging to Flat A, attempting to flood Flat A, but was ultimately frustrated by the claimant's contractors switching off water supply to Flat B from the streets, smashing newly fitted windows in Flat A, playing extremely loud music in Flat B and left that flat unattended whilst doing so, regularly fly tipping into Flat A's front paved area, as well as tipping water through the floor of Flat B over the lightings and electrics in Flat A's ceiling. The claimants further claimed under breach of covenant, amongst other things, that the defendants had permitted property to fall into disrepair in regards to a damaged guttering leading to damp and water ingress, damage to external walls, rear garden, and the defendant had derogated from the grant of the lease of Flat A by granting exclusive use of the front garden which formed part of Flat A's lease in a lease of Flat B, and then denying that the claimants had title to the front garden and the right to use the rear garden. Although the defendant was served with the claim form particulars in August 2019, the defendant made no attempt to defend the matter. Therefore, summary judgment application was made by the claimants on the 20th of July of 2020. Ultimately, summary judgment was entered in favour of the claimant by Mr. Hugh Southey QC, sitting as a Deputy High Court Judge in December of 2020. And in his judgment, he found the defendants had failed to comply with an earlier order by Master MacLeod, namely that he had to file and serve a signed witness statement which set out response and defence in time. The judge also held that the lease could not justify the defendant's behaviour, such as dumping rubbish in a front garden, and that the lease was clear on its face and there was nothing fraudulent. The learned deputy judge noted the defendant's expert opinion of a Mr. Ike Abanye, who was described as a founder and principal of an organisation called Architecture, but the learned deputy judge considered it inevitable that any court could give no weight to his evidence because Mr. Abanye had not indicated his qualifications, and even if he did have architectural qualifications, his opinions went beyond that of his expertise, since he, for example, referred to whether the signatures were questionable. The learned deputy judge was therefore satisfied that Section 1 was made out, and the defendant's conduct did amount to a breach of implied covenant for quiet enjoyment of the property. The claimants were entitled to relief under Section 3, and there was a sufficient basis for granting a summary judgment. At the hearing before the learned Deputy High Court Judge Matthew Gullett QC, the defendant had insisted that his decision was flawed, but that did not change the nature of the learned Deputy Judge's task in determining appropriate relief, as Mr. Southey QC's order remained valid unless and until it was set aside. The defendant also repeatedly sought to raise again his contention that the copy of Flat A lease held by Land Registry was inaccurate, but this had already been conclusively determined against him, therefore was not open to the defendants to reopen issues of liability, and that issue when dealing with the appropriate relief consequent upon the grant of a summary judgment. In their claim, the claimants first sought damages of pecuniary loss. The learned deputy judge found all past losses claimed were losses which had been caused by conduct of the defendants, and the defendant had failed to perform obligations towards the claimant as a freeholder and had conducted a lengthy campaign of harassment against the claimants, which ultimately had the effect of forcing them to leave their own home. The learned deputy judge also found that the claimants were entitled to recover sums spent maintaining and repairing the property as a result of the defendant's various acts and omissions, the sums incurred in installing security measures and costs associated with and consequent upon the claimant's decision to move out of the flat in 2019. The claimants further sought diminution in value of Flat A, and the claimant's counsel referred the court to the case of Raymond and Young, 2015, in which the Court of Appeal held that a claimant is entitled to damages representing diminution in value of land caused by the nuisance even where an injunction is granted. The learned deputy judge in this matter therefore considered the claimants should be awarded damages based on a diminution in value of the property caused by the defendant's conduct, similar to Raymond and Young. The judge found evidence in this case demonstrated the defendant's conduct was not transitory and that it was unlikely to cease even with the grant of a permanent injunction. The judge therefore accepted evidence of the claimant's valuation expert in determining damages representing diminution in the capital value of the property resulting from the defendant's conduct. Having awarded the claimant's damages under this head, it was therefore not open to learned deputy judge to make separate award of damages for past loss of amenity or for distress suffered as per Raymond and Young, though the judge did go on to set out what he would have awarded had it been open to the courts to make such awards. Therefore, the learned deputy judge ultimately granted a total sum in excess of £267,000 in damages and a final injunction with a penal notice attached against the defendant, which prevented him from, amongst other things, harassing the claimants, their family, their visitors, and placing any rubbish on any part of the property which belongs to Flat A. This case is therefore very helpful authority in identifying what type of injunctive relief or damages may be awarded by the courts in claims relating to nuisance, harassment, breaching covenants in the claimant's lease by a freeholder.
Well, I want to talk about a case that was decided at county court level in October of last year. So like the case discussed by Harriet, the two cases we're talking about today are quite recent cases. This case is called Fairhurst and Woodard, and it is a case that concerns the use of security devices in a domestic context, namely the use of a video doorbell and CCTV cameras. And this case, you may well be aware, has received extensive press coverage, in particular because the judgment relates to the use of CCTV cameras. And I will consider later on in my talk how significant this judgment is. Let us now think about what the claim is about. The claimant brought a claim for harassment, nuisance and breach of data protection provisions against the defendant. Now, you've already heard from Harriet that under Section 1 of the Protection from Harassment Act 1997, a person must not pursue a course of conduct, A, which amounts to harassment of another, and B, which he knows or ought to know amounts to harassment of the other. The claimant's nuisance case related to interference with her enjoyment of land. In other words, with the way in which the claimant was able to use her property and live in it. The claimant also argued that by using the home security devices in the way the defendant did, he breached data protection laws. The claimant argued that images and sounds captured by the defendant's cameras were personal data. The defendant, by contrast, asserted that he had a legitimate purpose, collecting and processing the data, namely to prevent crime. The claimant's case was that the processing was unlawful and her right to privacy overrode the defendant's purpose. The court was asked to consider whether the defendant had processed personal data captured by the home security devices lawfully and in line with a legitimate purpose, and one that was proportionate to the said purpose. Now, in order to understand the dispute between the two neighbours, it's quite important to be aware of the facts of the case. Now, the parties are neighbours, albeit not immediate neighbours, and they live in a small town in Oxfordshire. And the judgment states that, and I quote, "The claimant and the defendant had a somewhat remote but perfectly civilised neighbourly relationship before the events that brought them to court." End of quote. They live in two separate and adjacent terraces with back gardens. At the back of the defendant's garden is a shed. Between the two terraces is an access road that leads into a private parking area where there are a number of spaces owned by the local residents, including the claimant and the defendant. The defendant had installed a floodlight and a sensor, and also a video and audio surveillance camera with an integrated motion-sensitive spotlight on the shed in his back garden. The floodlight and the surveillance camera pointed in the direction of the car park. These two installations, however, are not the only installations that the defendant had installed. At the front of his property, the defendant had installed a combined doorbell and video and audio surveillance system, which pointed in the direction of the road going past the properties. On the gable of the building, the defendant had installed a second spotlight camera, which pointed down into the driveway leading towards the car park. Then the defendant had installed a camera on the windowsill of one of the windows of his property that pointed towards the road. By the time the trial took place, the defendant had removed the camera that pointed from the windowsill and the camera placed on the gable of the building. But the floodlight and the camera on the shed, both pointing in the car park behind the properties, and the video doorbell at the front door of his property remained. The defendant claimed that he had installed the various devices to protect his property after a criminal gang had tried to steal his car. He also claimed that some of the devices were dummy devices and they had been installed as a deterrent. The claimant considered that the defendant had not been open with her about the cameras. She took the view that the defendant had invaded her privacy and had intimidated her. The claimant said she had not been able to live in her home. She sought damages and an injunction requiring the defendant to remove the video doorbell and the camera on the shed, and also forbidding the installation of further cameras. In her judgment, the judge found that the camera installed on the gable of the terrace where the defendant lived surveyed an extensive area which included parts of the claimant property, such as parts of her garden and a side gate. None of the area the gable camera surveyed encompassed the defendant's property. The area could be viewed at any time by the defendant from an app. The camera would be activated by any vehicle or pedestrian using the driveway or any person leaving the claimant's side gate. The activation of the driveway camera would also activate an audio function so that any conversation in the driveway or in the area of the car park used by the claimant or in the claimant's garden were likely to be heard and recorded. The judge made similar findings about the other cameras. The camera on the defendant's shed routinely captured areas of the car park outside the defendant's own spaces and could be viewed by the defendant on his app. The judge found that conversations in the claimant section of the car park could be heard. And as regarded the video doorbell outside the defendant's front door, the judge found that the camera linked to the doorbell routinely captured an area outside the claimant's property, and conversations taking place at the claimant's front door could be recorded. The judge found that the camera on the defendant's windowsill captured people walking along the pavement between the claimant's property in the terrace where the defendant lives. The judge also found the images and sounds recorded by various cameras were recorded and uploaded to cloud storage until automatically deleted after 30 days. Now, the judge decided the case as follows. In relation to the harassment claim, she found that the defendant had engaged in a course of conduct which amounted to harassment. There were several occasions, she held, where he had caused the claimant alarm and distress, which, although not necessary, was within the concept of harassment. He had falsely told the claimant that he had sent her image to the police as an unknown suspicious person. He had deliberately tried to scare her during a telephone call. He had threatened to call the police regarding one of her friends, had threatened to set up more cameras, including concealed cameras, and had lied about 2 of the cameras being non-operational. His behaviour had crossed, and I quote from the judgment, the boundary between that which is unattractive and even unreasonable, and that which is oppressive and unacceptable. End of quote. A reasonable person in possession of the same information would consider, the judge held, that it amounted to harassment. To go from living in harmony with his neighbours to the level of belligerence, dishonesty, threats and oppressive behaviour exhibited by the defendant was unusual and alarming behaviour that amounted to harassment. The claimant, therefore, was entitled to damages for distress. The judge, however, dismissed the nuisance claim. She held that mere overlooking from one property to another was not capable of giving rise to a cause of action in private nuisance. And that conclusion is based on a case that I discussed in a previous Lamb Chambers podcast, namely the case of Fern and Tate Gallery. Another claim for nuisance caused by light from the driveway camera also failed. The judge held that a light triggering on and off probably was some irritation to the claimant. However, because she lived in a town and not the countryside, where nighttime lights were a feature, that didn't amount to nuisance, and it was not an undue interference with her use or enjoyment of her property. Nor was the value of her property materially reduced by the light, and the judge also held that it was not reasonably foreseeable by the defendant that the claimant would leave the property and live elsewhere because of the light. Now, turning finally to the data protection claim, the judge held that the images and audio recordings included the claimant's personal data. But the judge also found that the defendant's purpose of preventing crime was legitimate. The judge, however, found that the defendant had failed to act with transparency when collecting the data, because he had actively misled the claimant about whether the cameras were operational and what they were capturing. The fact that the defendant had misled the claimant undermined the defendant's argument that he was collecting the data for a legitimate purpose. The court also found that much of the image and audio collected was not necessary or proportionate to achieving the purpose of preventing crime. For example, the range of audio that could be collected by the doorbell camera was over 50 feet, going beyond the boundary of the defendant's property. And the court also found that the purpose of preventing crime could have been achieved without collecting the audio footage at all. Now, just to think with you a little bit about this case, as I've already mentioned, has resulted in much press coverage. It's important, however, to bear in mind that first, it's a county court decision and as such does not set a precedent. And second, it is fact specific. And indeed, it is very fact specific. And the judge, for instance, found the defendant to be an untruthful and a contradictory witness. It's also a rather extreme case of neighbour relations that had gone very badly wrong. The judgment, for example, records that the defendant had stated that the claimant could, and I quote again, go to hell, and that if the claimant did not like the defendant's cameras, and I quote, she would enjoy some of his future surveillance projects even less, end of quote, and that he was going to install cameras, and I quote, that were good enough to see the colour of her eyes, end of quote. So you can see it's a rather extreme case of very bad neighbour relations. In the reported decision, the court, unlike in the case discussed by Harriet, did not decide damages, but adjourned the assessment of damages to a later date, and I have not been able to find any information regarding the damages decision. So what can we take away from this case? Well, those concerned about their security cameras may want to consider the Information Commissioner's guidance about security cameras. That is quite long-standing guidance, which is called In the Picture, a Data Protection Code of Practice for Surveillance Cameras and Personal Information, which, among other matters, asks people to consider, for example, whether CCTV is really needed, whether there are other ways of protecting the home, and what areas are to be captured by the cameras, and whether the cameras can be positioned in such a way as to avoid an intrusion onto other properties, and also whether it is really necessary to have audio recordings. Moving away specifically from the data protection issue, what the decision also shows is that, in my view, a lot of problems can be avoided by being neighbourly and by trying to put oneself into one's neighbour's shoes and perhaps understand why the surveillance cameras may be considered a little bit intrusive. So we hope we've given you something to think about, and we thank you for having listened to and watched our podcast. Thank you very much.
Thank you.